Chair is authorized to declare a recess of the committee at any time. This hearing is entitled From Watchdog to Attack Dog, examining the CFPB's Chopra-Era assault on disfavored industries. Without objection, all members will have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. I now recognize myself for 5 minutes to give an opening statement. Today's hearing is titled From Watchdog to Attack Dog, examining the CFPB's Chopra-Era, one may describe as assault on disfavored industries. I would like to take a moment to thank the witnesses for being here to discuss the actions of the CFPB under the leadership of former Director Rohit Chopra. The CFPB was created to be a nonpartisan watchdog, an agency tasked with protecting American consumers from deceptive, unfair, and abusive financial practices. But under Director Chopra, that mission was largely abandoned. The CFPB ceased to be a pro-consumer agency and instead became an ideological weapon used not to protect the public, but to pressure businesses into aligning with the CFPB's goals through aggressive rules, enforcement, and supervision. Chopra targeted entire sectors he disfavored, wielding the agency's enforcement powers to intimidate and financially exhaust companies that didn't share his ideological progressive vision for the marketplace. One of the most troubling examples of this overreach was the aggressive use of civil investigative demands, or CIDs. CIDs are powerful legal tools that allow the CFPB to demand vast amounts of documents, data, and testimony, often with little to no justification or judicial oversight. Under Chopra, the CFPB issued CIDs to effectively weaponize the agency's authority to bury small firms in compliance costs and reputational damage before any wrongdoing was even proven. While a business can petition a CID, the decision on any petition was ultimately at the discretion of the director, sending it back to the organization that issued it in the first place. Unsurprisingly, Director Chopra denied 100% of the petitions that were received. Under the first Trump administration, 6 petitions were granted to overturn CIDs. For many businesses, especially small ones, the process of responding to a CID is a very challenging task, often leading to layoffs, loss of customers, and in many cases, closures. One of our witnesses here today will explain just how devastating these CIDs were. Under Chopra, the process became the punishment. The threat of a CFPB investigation was less about compliance and more about survival, especially for smaller businesses. This is not consumer protection. It is a bureaucratic attempt at intimidation, and it has no place in a system governed by the rule of law. So I applaud President Trump for ending this campaign of coercion at the CFPB. Businesses operating legally should not have to fear their own government. That's why today I've sent a letter to the CFPB's acting inspector general requesting a formal investigation into whether Director Chopra consistently exceeded his statutory lawful authority. Congress must act to ensure that the CFPB cannot be weaponized again. Under the Trump administration, legally operating ethical businesses no longer live in fear of the CFPB and their punishment. Chopra's tenure has made one thing clear. Congress must ensure the CFPB, or any agency for that matter, can never again be weaponized for ideological purposes. Of the countless banks and compliance officers, both large and small, that I've spoken to over the last 2 to 3 years, I have not heard from one that had anything positive to say about Director Chopra and the CFPB's work. And I've met with former Director Chopra several times and told him about these concerns, and it made no difference, and his CFPB continued its crusade. I look forward to hearing from the witnesses on how Congress can help the CFPB return to its core mission of protecting the American consumers from unfair and abusive practices. Sadly, the one investigating the abuses became the abuser. Now, I want to recognize my friend and ranking member of the subcommittee, the gentleman from Texas, Mr. Green, for 4 minutes for an opening statement.
Thank you. Thank you, Mr. Chairman, and I acknowledge you as a friend as well. However, notwithstanding the fact that the title of this hearing is From Watchdog to Attack Dog, I believe that a better title for the hearing would be from Watchdog to Lapdog, and how Trump's CFPB has abandoned consumers in favor of corporations. But it's not just the CFPB that's under attack, and we should not view these things in a silo, because if we do, we'll miss the big picture. Federal agencies are under attack. We are currently defunding the Department of Education, defunding HHS, defunding the FEC, defunding HUD, defunding FEMA. With all of these agencies under attack, we should understand that there's an effort afoot not only to defund the CFPB, which is, of course, being done, but also to literally remove from these agencies dollars, so that these dollars can go to the pockets of the very wealthy in this country. And it's not just from these agencies. The very essence of a country is the ability for its citizens to have good health care. We're removing dollars from health care so that persons who are very wealthy can have more money in their pockets. We seem to believe in this country that the poor can do more with less, but the wealthy need more to do more. This is an abomination. And I believe that Trump's CFPB has not only stopped initiating new investigations into abuses into the financial industry, it also has discontinued examinations that are ongoing from Director Chopra's CFPB. Most alarmingly, Trump's CFPB has taken the unprecedented step of rescinding settlements with companies that the CFPB had negotiated following investigations into consumer harm. In April, Trump's CFPB announced a wide-scale reduction in force affecting 90% of the agency staff. That 90% of agency staff cuts will benefit persons who are very wealthy. This administration seems to believe that you can take from the needy to support the greedy. I'm not with that. I believe that this country has been built upon the foundation of agencies that are helping people. The CFPB is at the very core of this, and we have to do what we can to protect consumers. We don't want the CFPB to become the agency for the financial institutions. It was for consumers. It has now become an institution that is going to protect financial institutions from consumers that are under attack. This is unimaginable. And finally, I want to mention something else as we move to closure. Something has happened today that I can't believe. The Trump administration has indicated that they will sue all 15 federal judges in Maryland over an order that those courts issued. Rather than appeal the cases, the Trump administration is now suing the judges who rendered the decisions. We've already heard the administration indicate that it would want to have judges impeached for decisions that it disagrees with. This administration is out of control. This administration is causing the demise of democracy to take place before our very eyes, and we have to stop it. We cannot allow American democracy to become authoritarianism with an authoritarian president. I yield back the balance of my time.
The gentleman yields. The chair recognizes the ranking member of the full committee, Ms. Waters, for 1 minute.
Thank you. Today, my colleagues on the other side of the aisle are holding yet another hearing to attack the Consumer Financial Protection Bureau under former Director Chopra's leadership for fulfilling his duties to protect consumers. That Consumer Financial Protection Bureau returned $21 billion to harmed consumers. On the other hand, under Trump's leadership, the agency has abandoned American consumers and the dedicated public servants who protect them. I'm once again calling on Chairman Hill to bring Acting Director Vaught before this committee to explain the Trump administration's unlawful efforts to delete the Consumer Financial Protection Bureau and fire 90% of its workers. Where is the accountability, Mr. Chairman? Unfortunately, for consumers, who broadly support having a strong federal watchdog protecting them from financial ripoffs. This Republican-led Congress is not providing it. Mr. Green, I join you in my outrage and disgust at this administration. They're trying to wear us out, and they're almost doing it. And of course, none of the members on the opposite side of the aisle are willing to stand up to
Gentlelady's time has expired.
this mess. I don't know if I'll stop or not.
Gentlelady is out of order. We will now move to witness testimony. Today, we welcome the testimony of Mr. James Kim. Mr. Kim is a partner at Cooley LLP, where he advises clients on compliance with federal and state consumer financial laws and regulations. Previously, Mr. Kim was a senior enforcement attorney at the CFPB. Mr. Kim holds a bachelor's degree from Brown University and a JD from Cornell University. We also have with us Ms. Jennifer Bassett. Ms. Bassett is the Chief Executive Officer of Pacific Rim Alliance Corporation, where she served for 17 years in several leadership roles. She also serves on the board of INFIN, a national trade group for consumer financial services, and CFSP, a California-based trade association. Ms. Bassett earned her bachelor's degree in mathematics from the University of Texas. We also have with us Mr. Devin Watkins. Mr. Watkins is an attorney at the Competitive Enterprise Institute, where he evaluates regulations and develops strategies to curb overregulation. He holds a computer science degree from Stevens Institute of Technology and a JD from George Mason University's Antonin Scalia Law School. And with us is Ms. Morgan Harper. Ms. Harper is the Director of Policy and Advocacy at the American Economic Liberties Project. Ms. Harper holds a JD from Stanford Law School, a master's degree in public affairs from Princeton, and an undergraduate degree from Tufts. So thank you all very much for being with us. My apologies. Each of you will be recognized for 5 minutes to give an oral presentation of your testimony. Without objection, your written statements will be made part of the record. Mr. Kim, you are now recognized for 5 minutes for your oral remarks.
Thank you, sir. Chairman Muser, Ranking Member Green, and members of the subcommittee, thank you for inviting me to testify today. My name is James Kim. I'm a partner at the law firm Cooley. I am presenting my own views today and not those of my firm or any of its clients. The CFPB has a critical mission to protect American consumers, and I believe in that mission. That's why I joined the Bureau in 2012 as one of the first enforcement attorneys in the New York regional office. Between working at the CFPB for 2 years and spending the last 11 years in private practice working on matters involving the Bureau, I've been immersed in agency matters over 3 different administrations. There's no question the CFPB over the years has strengthened consumer protections since its inception. But some of the Bureau's actions during the past administration exceeded the boundaries of the laws and rules that it enforces. Notably, the CFPB issued interpretive rules, guidance documents, and advisory opinions that supposedly interpreted or clarified federal consumer financial laws, but in reality sought to change the substance of those statutes and rules. These actions created confusion rather than clarity. It started enforcement investigations and filed lawsuits to create new compliance requirements rather than go through the public notice and comment rulemaking process mandated by the Administrative Procedure Act. This unilateral approach deprives stakeholders, including other federal agencies, state lawmakers, and state regulators from participating in policy discussions directly impacting their jurisdictions. The CFPB pressured companies to submit to the Bureau's supervisory authority, its most powerful and least transparent regulatory tool, under the threat of the Bureau exercising its so-called dormant authority to examine companies that posed risk to consumers. Compared to other federal agencies, the CFPB is still a startup, And like other startups who've gotten off the ground, it needs reminders to stay faithful to its mission and its core principles. And it needs adjustments to better execute its mission. Most importantly, the Bureau should focus on engaging with and gathering information from stakeholders at the ground level. All CFPB functions, from supervision to rulemaking to enforcement, should be driven by data collected from a wide range of sources rather than siloed, top-down decisions from agency leadership. Thank you again for the opportunity to testify today. I look forward to any questions that you may have.
Back, Ms. Bassett, you are now recognized for 5 minutes for your oral remarks.
Thank you. Chairman Muser, Ranking Member Green, and members of the subcommittee, thank you for the opportunity to testify before you today. My name is Jennifer Bassett. I'm CEO of Pacific Rim Alliance Corporation, a small women-owned financial services company based in Phoenix. For 36 years, we've provided small dollar loans and essential financial services to underserved consumers. We are a state licensed, federally compliant business with no outside investors. Our customers are everyday working people who rely on our services for short-term credit when traditional options fall short. Our products help them afford urgent car repairs, appliance repairs, and avoid utility shutoffs, overdraft fees, or even eviction. I'm here today because our business, along with others in the small dollar lending sector, were designated for enforcement by the CFPB under Director Chopra's leadership. The CFPB pressured our small compliant business to the brink, not because of any proven wrongdoing, but due to a bias against our industry. We are a small company that is getting smaller. Since the start of this targeted enforcement campaign, we have closed 35% of our locations and laid off a third of our staff. We currently operate 30 branches across 5 states and employ 80 people. At some of our lower performing locations, as they approached lease renewals, we were forced to make difficult decisions, including closing branches we had successfully operated for over 25 years. Rather than reinvesting to improve underperforming branches, we had to divert resources, both financial and human, to comply with burdensome demands by the CFPB. We've been the subject of an ongoing investigation by the CFPB for 3 years, since July of 2022. The Bureau has issued 3 CIDs, each more burdensome than the last. None has been tied to any specific allegation, consumer complaint, or exam finding. Despite our full compliance with the first CID, which included producing over 11,000 pages of documents and my participation in an entire day, 8 hours of testimony, we never received any follow-up or feedback from the Bureau. Rather than focusing their investigation, we received a second sweeping CID demanding detailed data on every loan made for a period of 6 years, as well as all internal communications, all personnel files, and more. We were also expected to review and produce 3.8 million emails. Still, no violations were cited. The third CID requested additional written responses and multiple investigational hearings with employees. Each time we complied in good faith. We had to hire outside counsel. We don't have in-house attorneys. The legal fees and costs have now reached nearly $500,000. $500,000 is an extraordinary burden for a company of my size. We petitioned the Bureau twice for relief. Both petitions were denied by the very agency that issued the demands. There is no neutral arbiter, no check on the Bureau's authority. Director Chopra served as the judge, jury, and executioner. Even worse, after submitting confidential financial data to support the tremendous strain we were under in our first petition, the CFPB published our sensitive business and financial information while redacting their own most aggressive CID demands. This kind of selective transparency has a chilling effect on participation and intimidates businesses. We have a history of working cooperatively with the CFPB. We underwent full, lengthy examinations in 2015 and 2018 with no violations of law, 0 fines, and no penalties. We suspect we were targeted in part because I participated in the 2015 Sabrifa panel for the CFPB's small dollar lending rule. When that rule was deemed unworkable and largely rescinded, Chopra's Bureau shifted tactics, regulating not through rulemaking, but through enforcement. Multiple small lenders like us were hit with nearly identical CIDs. This wasn't a company-specific investigation. It was an intimidation campaign against our industry. Director Chopra has claimed that the Bureau was focused on large participants and repeat offenders. But our experience tells a different story. We are neither large nor a repeat offender, yet we've been hammered, our reputation damaged, and our ability to serve customers weakened. This is not how regulatory oversight should function in America. Enforcement should be targeted, fair, and transparent, not arbitrary or punishing. The current CID process lacks procedural safeguards. That is why I urge the subcommittee to support real, meaningful reforms to this process, including supporting the bipartisan CID Reform Act. The CFPB should be a watchdog, not an attack dog. Thank you, and I look forward to your questions.
Thank you, Ms. Bassett, for your testimony. We now recognize Mr. Watkins for 5 minutes for his remarks.
Chairman Muser, Ranking Member Green, and members of the subcommittee, I appreciate the opportunity to speak to you today. My name is Devin Watkins. I'm an attorney at the Competitive Enterprise Institute. CEI has advocated for nearly 40 years for a more accountable government rather than bureaucratic control so that people can live freer, healthier, and more prosperous lives. 2 years ago, I testified before this committee to express serious concern about the structure and conduct of the Consumer Financial Protection Bureau. I proposed reforms to the CFPB, and shortly after my testimony, the Supreme Court granted review in Jarchese, and last year agreed with me that jury-free administrative trials for the imposition of fines, like those used by the CFPB, are unconstitutional. The absence of a reform I proposed that rules clearly define unlawful actions before enforcement led to the abuses I will discuss today. Regulatory enforcement abuse like that occurred at the CFPB is just another form of prosecutorial abuse. A normal prosecutor waits for a potential victim, examines the evidence to see if a well-known violation of law occurred, and then brings enforcement to protect that specific victim. The problem occurs when prosecutors follow the old Soviet saying, "Show me the man, and I'll show you the crime." That chilling phrase reflects a regime where law is not a constraint on power, but a tool of it, where the decision of who to investigate comes first, and the legal justifications follow later. Where the government doesn't apply well-known rules, it invents them for the occasion. Sadly, this has become the reality of too many businesses facing CFPB enforcement actions. Let me illustrate with 3 concrete examples. Consider the case of Comerica Bank, which CFPB sought to penalize over consumer call wait times. I know the CFPB regulates banks, but there's no law or CFPB rule stating how long is too long for a wait time. The agency simply declared that the wait time was too long and sought to retroactively punish Comerica for violating the new rules. John Locke described freedom as having a standing rule to live by, not to be subject to the inconstant, uncertain, unknown, arbitrary will of another man. If a company cannot know in advance what conduct it will be punished for, that is not regulation, it is an ambush. A second example involves Acoma, Snap Finance, and the broader rent-to-own industry. Such rent-to-own leases were not previously treated as credit, but one day the Bureau simply announced they were now subject to its authority as credit products. And then in violation of the ex post facto prohibitions, or at least the spirit thereof, the CFPB fined companies for transactions that occurred before the new interpretation was announced. Lastly, Townstone Financial is a small Chicago mortgage company. The CFPB didn't go after Townstone for denying anyone a loan. There were no consumer complaints. So what was CFPB's issue? Townstone's owner, Barry Sterner, had a weekend radio talk show. On the radio talk show, Mr. Sterner expressed concern about crime in the urban neighborhoods. CFPB targeted Townstone Financial for his protected speech. The CFPB then destroyed his business by claiming complaints about neighborhood crime on the radio were really disguised attempts to dissuade minority applicants for mortgages. Facing a mountain of fines, and after 7 years and spending $1 million to defend itself, Townstone was offered a settlement for $105,000. That might sound big, but it is less than it would cost to hire a private attorney to fight those charges in court. Townstone was defended by many great lawyers, including Pacific Legal Foundation, an excellent nonprofit law firm that defends many worthy causes. Townstone's costs could easily have doubled but for the legal assistance provided pro bono, but still the burdens of litigation were too much for Townstone to continue. Coerced plea agreements are far too common in today's legal system. When people are facing millions in fines and offered a settlement for less than what it costs to defend yourself, many innocent people give in. A coerced agreement of an innocent person is not a badge of honor for the prosecutors, but a mark of shame. These cases represent a broader pattern where the CFPB has brought cases for the purpose of stretching its authority. Congress never gave CFPB authority to regulate consumer call wait times, comments on radio talk shows, or rent-to-own leases. The agency just seized that power. Fortunately, there is cause for hope. Under new leadership, the CFPB has dismissed many of these abusive actions. It has also tried to unwind the Townstone settlement, recognizing that the enforcement violated the First Amendment. But shockingly, a federal judge has refused to let the agency correct its own mistake. According to the judge, the people cannot be allowed to select new leaders to reverse constitutional violations by their government. A president has the power to pardon even the most atrocious terrorists and traitors. But for some reason, an unconstitutional settlement in a civil proceeding cannot be vacated. This is wrong. The rule of law is not a partisan issue. It is the foundation of our republic. Thank you.
Thank you, Mr. Watkins. Ms. Harper, you are now recognized for 5 minutes.
Thank you. Chair Muser, Ranking Member Green, members of the subcommittee, thank you again for the opportunity to testify about the CFPB today. Since its inception, the CFPB has enforced laws to protect consumers and honest businesses. Today's hearing is about attacks, but let's be clear who is attacking American consumers and competition. It is this administration's unleashing of corporate lawlessness and the rejection of CFPB's true law enforcement mission. This mission is personal. Though I currently serve as the Director of Policy and Advocacy at the American Economic Liberties Project, a few years after the financial crisis, I left a corporate law firm to join the agency, appalled how private equity-funded corporate giants profited from the crash, while so many communities in my home state of Ohio were still reeling economically. I had heard this new agency was trying to do something about it, and I wanted to help. We wrote rules for prepaid cards and sued Wells Fargo for opening millions of fake accounts in customers' names. And though it garnered fewer headlines, I am also extremely proud of how we looked out for special populations like older Americans. My own 82-year-old mother lost an entire month's pension in a scam involving prepaid cards, a painful violation too many American families have experienced, and then reported to the CFPB. In fact, the CFPB has processed over 10 million consumer complaints, returning on average over $1,400 each. The agency has used every tool Congress bestowed to deliver real results, returning $21 billion to over 200 million Americans and forcing lawbreakers to pay more than $6 billion in fines. Former Director Chopra continued this legacy of cracking down on illegal conduct, whether perpetrated by Wall Street, big tech, or newer companies. Under his leadership, the agency confirmed that buy now, pay later lenders are credit providers and subject to the same legal protections as credit cards. The agency held data brokers accountable for how they mismanage consumers' personal financial information. And through the open banking rule, the CFPB expanded consumer access to financial data, to their own financial data, allowing companies of all sizes to compete. The agency took action to ensure fintech companies follow federal laws, cracking down on debanking and holding repeat non-bank offenders like TransUnion accountable. Chopra's CFPB also did not shy away from suing big guys like Bank of America, Apple, and Goldman Sachs for numerous violations. Acting Director Russell Vogt, however, has veered dangerously off this course since assuming his role in February. He has taken a sledgehammer to the agency's enforcement function. The CFPB has dismissed or withdrawn more than half of its pending cases with no explanation. Talk about arbitrary. And many of these were permanently dismissed. Vogt is letting JP Morgan, Wells Fargo, and Bank of America off the hook for $870 million in fraud on the Zelle platform and dropping a case against Capital One for cheating consumers out of $2 billion in interest payments. It comes as no surprise that both JP Morgan and Capital One donated to the president's inauguration fund. The current administration, CFPB, has not just handed out corporate pardons to their friends on Wall Street, but also reversed course on already negotiated settlements, robbing consumers blind. Chopra's CFPB ordered Toyota to pay $60 million for illegally raising borrowers' monthly car payments. Last month, Trump's CFPB inexplicably terminated the agreement. It's again of note that Toyota donated $1 million to the president's inauguration. And as Americans continue to manage increased costs, the current CFPB, along with the congressional majority, has rolled back rules that would limit junk fees, including overdraft and credit card late fees. Estimates suggest Vogt and Trump's rollbacks have already cost Americans $18 billion, almost as much as CFPB has returned to the public since opening its doors. In the background of this destructive policymaking are CFPB employees in limbo, punished for working to prevent any American family from experiencing the pain of being cheated, scammed, or made homeless by a faceless corporation that doesn't give a damn. After the worst financial crisis since the Great Depression, Congress created the CFPB to ensure, quote, all consumers have access to financial products and services, and that markets are fair, transparent, and competitive. Chopra CFPB fulfilled this congressional mandate to protect American consumers, mitigate risk to our financial system, and enforce the rule of law without fear or favor. It's a mission 82% of Americans, including 77% of Republicans, support. Congress should push this administration to resume the work of stopping lawlessness instead of enabling it. As household debt teeters on $20 trillion and loan delinquencies rise, the administration's reckless
Gentlelady's
rollback
time has expired.
of the CFPB law enforcement agenda
now turn to
is
member
something that
questions.
threatens financial stability. Thank you.
Gentlelady's time has expired. Please follow the rules. We'll now turn to member questions. The chair now recognizes himself for 5 minutes. So thank you for your testimony, all of you. Interesting perspectives, real-life examples of unbelievably abusive overreach that have caused you to fly in from all over the country where you could spend your time doing many other things, but you want to come here and talk about the tyrannical crusade taken within a government agency, and we're not going to stand for it. That this is America, and it's going to remain a free society, not one where an agency feels it can do whatever the hell it wants. So that's where we start. So, Mr. Kim, in your view, was the Bureau's primary mission to protect consumers through even-handed enforcement of clear rules? Was that pretty much?
Yes, sir.
Yes, sir? So you think did they carry out the mission even-handedly to protect consumers?
During the last administration, I think the record is clear that certain actions exceeded its legal mandate and its legal boundaries.
Okay. Well, I guess that means that they did things that were unlawful according to their scope and their mission and their legal authorities. So, Ms. Bassett, flying in from Phoenix, where you, of course, would have better things to do, like keeping your company alive and functioning. You have been under CFP investigation, which you expressed. And before that, you had been in regular contact with your state regulators. You're a very regulated industry and business. Would you describe those relationships with your state regulators as fair and constructive?
Thank you for the question. Yes, our relationship with our state regulators has always been great, and it's very collaborative and effective.
So the big difference between your state regulators that have been doing their business for a long time and then enter the Chopra-Era, and you had different experiences, to say the least. You want to elaborate on that?
Thank you, Congressman. Yes, it was extremely different that we received our first civil investigative demand just out of the blue. We had been through 2 prior examinations in 2015, 2018, no fines, no violations, and then all of a sudden we just get this civil investigative demand with no clear purpose, and the amount of data that they expected from us was just overwhelming. It's consumed over half of my time for the last almost 3 years.
Last 3 years. And what sort of rationale do you give to these CIDs? What were their purpose? And then what were the results of these CIDs to your company's reputation? Did it help you improve your relationship with your consumers? Did it protect any consumers? Did it provide reputational harm, personal burden, business disruption? Or was there any glimmer of helpfulness in their oversight and intrusive behavior?
Thank you for the question. There was absolutely no benefit to consumers based on this investigation. It's still open actually today, but we have never had a clear understanding of what they're looking for. They asked for just everything we had, and we kept trying to narrow the scope and say, could we work this out? And we tried to comply the whole time, and It is just, I don't know what the end was going to result in. We never got there.
Thank you. Mr. Watkins, you've got vast experience, many years in this industry, dealing with oversight bureaus, dealing with government regulations, and yet you use the phrase, show me the man and I'll show you the crime, in order to describe the Chopra CFPB. So you obviously believe that these tactics that were being used with the CID and everything else were overly aggressive. Could you elaborate?
Yes, there are many times I think where the CFPB has chosen what its targets are first before it has any evidence that a crime has occurred or even there's any reason to believe a crime has occurred. I really think the government needs to have some kind of at least probable cause to believe there is a crime before it creates enormous burdens and harms these companies.
All right, thank you very much. I yield back. I now the gentlewoman from California, Ranking Member Waters, is recognized for her questions for 5 minutes.
Thank you very much. First, I'd like to ask those who have come here to undermine the Consumer Financial Protection Bureau, do you believe that it should be deleted? It should be deleted from government altogether, each of the three who have testified. You want to eliminate it altogether?
No, ma'am.
Yes or no?
No.
Yes.
Yes or no?
Yes.
Yes or no?
I would have Congress write the rules and transfer its enforcement authority from the CFPB to the Department of Justice.
You made an interesting statement. You said that the President Trump has the power to pardon even the most atrocious terrorists and traitors, but for some reason, an unconstitutional settlement in a civil proceeding cannot be vacated. And I'm so happy that it cannot be vacated, because you're right. You're absolutely right. He supports the terrorists. He supports those who came to the Congress of the United States to kill us all. Thank you for that in the record. Now, let me go to our witness, Ms. Harper. The Consumer Financial Protection Bureau has returned $21 billion to consumers. Do you believe that alone should justify the work that they're doing? And do you believe that in early May, Trump's Consumer Financial Protection Bureau asked a federal judge to scrap the previously finalized medical debt that would take medical debt off credit records and help 15 million people in the U.S. with unjustly lowered credit scores due to medical debt? The Consumer Financial Protection Bureau previously researched this matter and found medical debt has little value in predicting a consumer's credit worthiness. So, should someone who experienced an unexpected medical event through no fault of their own deserve to end up with a damaged credit score that prevents them from getting mainstream credit or forces them to pay much more for a loan?
Thank you for the question, Congresswoman. And I think the $21 billion figure that the CFPB, the money that CFPB has been able to return to consumers, is evidence of just how effective it is as a regulator of the consumer financial markets. I think the reason why it should continue to exist is because Congress said so, and we should respect the rule of law. It hasn't been a priority of this administration or the leadership under of Acting Director Vogt, but that is something that is a principle of this country. Regarding medical debt, I'm glad you mentioned it, because this has been a very troubling development in this administration, seeing the lack of support for doing something about this industry. We have millions and millions of dollars and millions of consumers that are now being caught up in the system of their debt their debt from a healthcare system that has been monopolized by corporate giants and has not been checked yet through government action, now informing credit decisions. And really what the result of this could be, and a question that this committee needs to be asking itself, is, do we want a system where a healthcare giant like United Health Group is now determining who gets mortgages in this country, whether you get a credit card? That's the end result of this kind of reckless decision-making from this administration and not supporting the medical debt rule, which would address some of the abuses that have been happening in that industry.
Thank you very, very much. You know that The chairman here today talked about rules, follow the rules. He even made that point when he talked to you. Do you know and understand that the Consumer Financial Protection Bureau director should be brought, according to the rules, before this committee every 6 months, and it has not been done? Why do you think they didn't follow the rules?
Well, it's a great point because, yes, that is an obligation that has not been fulfilled. I think it's very interesting for all of us as panelists to share our views on different consumer financial protection policies, but the elephant in the room is there's a guy that's in charge of that right now. His name is Russell Vought, and he should be here at this hearing explaining some of his decision-making. I mean, I'd also like to come back to this Townstone case, because following the rules, well, we had in that case a Republican judge who agreed with the settlement that had been negotiated by the CFPB, a panel of judges that also were Republican appointed that agreed to it, and then this administration is saying, oh no, don't worry, we no longer care whether fair lending laws have been violated. Follow the rules? What are we talking about?
Wow, it couldn't be better stated. What are we talking about? I guess I'll yield back to time so he can continue with this hearing. All right, thank you.
Mr. Chairman, if
I
I
yield
might have a
back.
minute.
The time has expired. We will now, the chair now recognizes the gentleman from Georgia, Mr. Loudermilk, for 5 minutes.
Thank you, Mr. Chairman. Before I start with my questions, Mr. Watkins, I'll yield a little time for you to respond.
I just wanted to correct the record. I did not say the current president supported terrorists and traitors. I was talking about any president's power, whether that is Biden, Obama, or any president to pardon terrorists and traitors. Such abuse of people being given a second chance, civil penalties should also fall under the same provisions.
Thank you, Mr. Watkins. This is reclaiming my time. This is my time. Mr. Kim. In your opinion, did the Chopra-Era CFPB target companies outside the financial services industry through enforcement actions?
Yes, sir, and I believe Mr. Watkins touched upon a few examples. One public one is the rent-to-own industry. It's not new. It's been around for decades. About 46 states have rent-to-own specific laws and regulations. It's also policed by the Federal Trade Commission. It's clear in the law that it's not an extension of credit under the Bureau's jurisdiction, but the CFPB under the past administration brought multiple enforcement actions and lawsuits against that industry. And it took that industry 4 years, or the companies involved, 4 years to be vindicated with a dismissal in federal court with a decision by a district court judge, not a dismissal by the Bureau.
So it was dismissed by the judicial branch that there was nothing to the accusation. How many millions of dollars were spent defending that?
I don't know and I can't say, but like I said, it took several years to get that vindication.
And the industry obviously suffered, but would it not be the consumer who ended up really bearing the costs of those actions?
I presume so. Companies tend to pass on costs to end users if there are costs imposed on them.
So that wasn't a whole lot of protection of consumer finances, was it?
Not that I'm aware of, especially
Okay.
when states can police that industry.
Right. Mr. Watkins, did any Chopra-Era CFPB regulations undermine other federal or state regulators' existing regulatory authority?
Yes, commercial bank that I was talking about, they were directly regulated under the oversight of the financial services of the Department of the Treasury. The CFPB went after them in some sense because they thought that the Treasury Department wasn't being aggressive enough.
Okay. Ms. Bassett, how would you describe your engagement with the CFPB's team in terms of your request to modify the various CIDs, the civil investigative? I'm forgetting the term. Thank you. The various CIDs they served on you, and making those requests, you weren't trying to hide anything, were you?
Thank you for the question, Congressman. Absolutely not. We did try to work with them in their meet and confer process, where we asked that they just narrow the scope, because they were asking for everything that we had, and the experience is just detrimental to a company my size. And when I said I want to delete the CFPB earlier, the reason that I would even go that far is because my experience with my company has been horrible. It has really hurt our company and our reputation. I've been through examinations with them with no issues, but that was also so time-consuming and crazy when we already are state-regulated and examined by our states all the time. So thank you.
The CIDs we're talking about are civil investigative demands.
Yes.
These are demands on your company that you have to respond, whether you're guilty of anything or not, or they're not even accusing you of anything.
No, they were not. They issued these CIDs to at least 4 or 5 companies in our industry with the exact same notification purpose and the exact same document request. So it wasn't company specific to me.
So they had no probable cause.
Correct.
They're just fishing.
It was a fishing expedition.
Which is a violation of the 4th and 5th Amendment of the Constitution. And so the Bureau's investigation of your company has taken 3 years. In that time, and to this day, were you ever told of a single violation of your company guilty of? You said no, correct?
The gentleman's time has expired.
Thank you, Mr. Chair. I yield.
The gentleman yields. The chair now recognizes Mr. Liccardo of California for 5 minutes.
Thank you, Mr. Chair. Thank you to our witnesses for coming to testify. Ms. Harper, I was very interested in your testimony, specifically about specific actions that were taken by CFPB, the Consumer Finance Protection Bureau, against companies that subsequently were dismissed. My understanding was in November of 2023, Toyota settled a $60 million illegal scheme that increased monthly car loan payments on consumers. You indicated Toyota was a contributor to President Trump, is that right?
Yes,
And how much?
$1 million, I believe.
And in May of 2025, the consent order that Toyota agreed to was actually terminated by the administration, is that right?
Yes.
Is there much precedent for an administration terminating a consent order that the opposing corporation actually agreed to?
No, I think it's fairly safe to say that what we're seeing from the current CFPB led by Acting Director Vogt is beyond any normal parameters of what we would expect from a financial regulator.
And do we know anything about the $48 million that was supposed to be returned by Toyota to consumers?
In terms of?
That consent order, was any of that money actually returned?
No, I don't think a dollar has been returned yet. So when I said in my opening testimony that this is really robbing consumers blind, this is money that should have been going back to consumers who were harmed, and especially in this period where we know that the American public is facing so many challenges around the cost of living. It's really inexplicable to be adding to that burden and preventing consumers from getting more money. And the last thing I would add is, and these are legal violations. This is a law enforcement agency. We should be all encouraging that. That should be a bipartisan issue. And the fact that it's not says a lot about who Russell Vogt wants to benefit in this administration. They're friends.
Let's go to that in a moment. Bank of America and JP Morgan were both under investigation regarding the Zelle network, regarding a failure to reimburse customers that were defrauded by scam artists. And that action was taken to the CFPB. And what was the result of that action?
Those are also among the cases that have been dismissed.
And Bank of America contributed to Donald Trump in his inauguration, didn't they?
Yes.
Was it $500,000?
I believe so.
And JP Morgan, another $1 million?
Yes.
And Capital One, the evidence from the CFPB indicated they may have cheated customers out of as much as $2 billion. How was it that Capital One engaged in that fraud?
Yeah, so what was happening in that case was that Capital One was signing consumers up for accounts that they said were going to be high-yield interest accounts, that consumers, by putting their money in those accounts through interest payments, would be able to earn some additional money. And instead of actually doing that, they were keeping them in lower-yield accounts and not telling them. And so, again, just another example of straight up taking money away from people in this country that need it more than ever. And especially when we're looking at an institution like Capital One, talk about repeat offender, long litany of legal violations. And that's why it was also very disconcerting to see from this administration that they greenlit the Capital One Discover merger that's only going to increase Capital One's market power and make it really difficult for small businesses and consumers to get ahead.
And Ms. Harper, Capital One contributed $1 million to Trump's inauguration.
Also true.
And what happened as a result to the CFPB case?
They got their case dismissed.
I am puzzled as to why we're having this hearing. As we were watching the defunding of the financial police happening over the last several months and weeks, all I have heard is criticism of whatever happened in the last administration. And I'm sure there's plenty of criticism that's legitimate against the last administration. I don't understand why we're still spending time on whatever happened in the last administration when we know what's happening under this administration is so corrupt and so clearly undermining the interests of every American consumer. I hope that our next hearing is going to actually focus on protecting American consumers and what we can do now and prospectively with a CFPB that has been utterly gutted as the Republicans continue to defund the financial police. I yield.
Gentleman yields. The chair now recognizes Mr. Herodopoulos from Florida for 5 minutes for his questions.
Well, thank you, Mr. Chairman. I appreciate this conversation, and it's one that's been having way too often in the idea of that this previous administration seemed to pick winners and losers over and over again. And let's just be clear, if the CFPB did not exist, it does. If it did not exist, there are still 12 different federal and state regulators that can oversee these financial markets. And as many people have been said, after they created the CFPB, you could have just consolidated all this into the FTC. After all, it's been around, as a history teacher, I know this, since 1914 in the Progressive Era. And so let's make sure that this is not some Wild West we're talking about here. There are 12 different agencies that oversee these type of things. But what we have heard consistently in this very committee, and as both Mr. Moore and I are new members, is that this agency was playing politics. And that's the frustration I think we're going through, is that they would pick on folks who they necessarily didn't like, and they would run them into the ground, run up expenses, and make it very hard for them to compete in an increasingly competitive world. And so I'm glad to see we're having conversations like this. And let's also be clear that the U.S. Supreme Court aggressively told the CFPB that they violated the 7th Amendment. That was a recent Supreme Court decision. And now all we're asking is saying, hey, CFPB, would you mind following the APA standards? That's a good idea, so we can actually know what the rule book is. Because in this committee, we've heard over and over again, it's the reason why our chairman, Mr. Hill, has been so effective. He was saying with things like cryptocurrency and the blockchain, let's make sure we know who is actually going to regulate it, so out of control regulators don't get to pick winners and losers. I think that's a common sense thing to do. And so, Mr. Kim, let me ask you this with that premise. We saw the violations of the 7th Amendment. The Supreme Court ruled very clearly on that measure. What are we doing now? As I think that our previous questioner asked, what are we talking about in the future? I can't go in the past either, folks. Let's talk about the future. What can we do so we don't have these fishing expeditions and these people don't pick winners and losers before they even get into the game? What have they done to make sure this doesn't happen again?
If we're looking forward, I think the guidelines and rules are clear, and you've referred to them. There's the Administrative Procedure Act. There are a host of requirements for public rulemaking through a transparent process. So I think that's your answer, sir, is that,
Let me ask Mr. Watkins.
rules are
Mr.
there.
Watkins, I'd love to get your opinion.
We need to do more. The APA is not sufficient here. We should require that any kind of civil investigative demand go before a judge to show that it is reasonable in its scope and that it's supported by probable cause, and allow the individual or business to dispute that before the judge, to ensure that these businesses are protected from these enormous burdens before they are forced to undertake them.
And I'll just close with this, Mr. Chair. I want to thank Ms. Bassett for coming in. These are not easy, and I know that these challenges you've had, and I appreciate your willingness to testify, because some people like to play games and retribution, and it's very much the wrong way just to do things. And also I mentioned, the last thing we want to do in this business is start getting into the discussion about who gave money to who. I mean, I think it diminishes the quality of the conversation we can have here. What I'm excited about is that we're taking a fresh look at whether it be the CFPB, whether it be how the FEC regulates or the CFTC regulates. That's I think the mission of our committee. And I'm glad to see that our chairman here has done a great job of bringing testimony forward, because I don't want to litigate fights in the past either. I want to move this country forward, and I'm glad to see that we're taking a fresh look about how we administer the APA and how we're going to, when a company comes into play, they feel like they're going to have a fair umpire instead of someone coming in and picking winners and losers with clearly some of the folks before we're done. And I'm not here to litigate that, but I am here to litigate the idea that we are going to use this committee effectively, find out what the consumer is dealing with, and when they go before one of these huge federal administrative agencies, that they feel like they're going to get a fair shake and that the die has not already been cast. So, Mr. Chairman, I applaud this oversight meeting, and I think it's going to be very helpful as we move forward once we complete the work with Bitcoin, cryptocurrency, and other crypto-type measures. Thank you, Mr. Chairman. I yield back.
I thank the gentleman for his remarks. The gentleman yields back. I now recognize Ms. Williams from Georgia for 5 minutes.
Thank you, Mr. Chairman. Y'all, as I prepared for this hearing, I was initially very excited because I thought maybe the hearing would focus on oversight of the CFPB, and I'd finally get an answer about all of the jobs lost and the consumer protection investigations that have been halted after my Republican colleagues stood by as the Trump administration has gutted the CFPB. But then I read the title, From Watchdog to Attack Dog. And I guess my Republican colleagues are right about something. They've consistently attacked the CFPB and consumer protection since I've arrived on this committee. No matter what the facts are, my colleagues on the other side of the aisle, they just want to continue to attack the CFPB under the guise of accountability. Well, here are the facts. Congress has already placed conditions on the CFPB to ensure that it's accountable. Now we just need the Trump administration to follow the law, which seems to be a pretty high bar in this administration. The CFPB director is required to testify before this committee twice a year. We haven't had that first hearing yet, y'all, and it's almost July. But it might have something to do with we still don't have a permanent director at the CFPB. It's a shame that we're here today to help my Republican colleagues feel like they care about accountability with the sham of a hearing when we could and should be focused on consumer protections. But let's be real. This hearing isn't about making the CFPB work better. House Republicans are just hurt that former Director Chopra prioritized the most important piece of our financial system, the consumer, and not their billionaire buddies. Despite how some of my colleagues feel, the work of the CFPB, well, the work that the CFPB did do before it was gutted, and we're still dealing with that, but it was imperative for my constituents in Atlanta, across the 5th District in Georgia, and across the country, in Democratic and Republican districts, because the CFPB is nonpartisan. Reducing excessive junk fees, that's nonpartisan. Relieving the burden of medical debt on consumer credit reports, that's nonpartisan. Combating housing discrimination and holding banks accountable for deceptive practices, that's nonpartisan. These are consumer protections. Are we really describing those actions as those of an attack dog? To me, those are actions that are all critical to the financial well-being of the American people. People that I fight for every single day in Congress. People who are seeing prices skyrocket under the Trump administration. People who already couldn't afford to buy a home, send their kids to college, or just get ahead because of years of my Republican colleagues blocking investments in people and communities who need them most. And with the Trump administration's lack of a consumer protection agenda, he's already turned the consumer's watchdog into a muzzled little puppy. In my district alone, according to the Student Borrower Protection Center's own data, the CFPB helped over 196,000 consumers find financial relief in Georgia's 5th District. That's not an attack dog, that's a watchdog for the people. So I want to take this time to help American consumers understand exactly what is happening now that we don't have a consumer watchdog. And I'll start with you, Ms. Harper. Ms. Harper, I understand that you used to work at the CFPB, and we thank you and your colleagues for your work and service on behalf of the American people. Georgia's 5th District is home to 13 higher ed institutions and the largest consortium of HBCUs in the nation. For many young consumers in my district, especially first-generation college students, they're taking out a loan for the first time to finance their education. Students may also be opening a bank account or getting a credit card for the first time on campus. And this makes students a very captive market for financial firms. Ms. Harper, how are students currently at risk of being targeted without protections from the CFPB?
Thank you for the question. And yes, your point about being marketed when you're a young person. I mean, my brother fell into one of those traps.
I fell into those traps.
Yeah, and it used to be very bad before there was a cop on the beat. And in order to continue to make sure laws are enforced, you have to have people working at the CFPB to supervise some of that conduct. Right now, based on the decisions out of this administration, we've seen the supervisory staff drop from a few dozen, in some cases for certain departments, to just a handful of people. That is not enough to keep track of what's going on out there in the market to protect students. And if I may just clarify a couple of other points that have come up, because I think, a lot of today's focus is that suggesting that there's some targeting, and Ms. Bassett, though, I heard some of her testimony. I think it's important to keep in mind, again, that the CFPB's mission is to follow legal violations. Sometimes people who conduct and participate in legal violations, it's not comfortable to go through that process.
My time has expired because this conversation is so important in protecting the consumers. Mr. Chairman, I yield back, and I look forward to having this conversation as we continue to work on this committee to protect consumers in this country.
Gentlewoman yields. The chair now recognizes Mr. Moore of North Carolina for 5 minutes.
Thank you, Mr. Chairman. This has always been an intriguing subject for me because before being a member of Congress, I was an attorney for 30 years. And during those 30 years, I had cases over the time where I actually represented victims who were defrauded, civilly defrauded, some actually criminally defrauded. And I'm a big advocate for consumer protection. But I'll tell you, under the former director, under Director Chopra, the CFPB was essentially, I would say, fundamentally reshaped to reflect a progressive agenda, prioritizing aggressive enforcement over clear guidance and balanced oversight. And the big injustice that always stuck out to me, and we've talked about this before the committee hearings, was how rules are made up on the fly. They would be like press releases that came out. And then the fundamentally flawed way that the agency was funded was it got more money based on the amount of fines and penalties and so forth that were leveraged. I mean, that's just fundamentally unfair. And so and Mr. Herodopoulos made the good point that consumer protection has been the law before this monstrosity of CFPB was ever dreamed up, where you've had multiple agencies. States have, laws dealing with consumer financial protections, with unfair and deceptive trade practice. There's other federal agencies that cover this. And this, you simply had an agency that I would submit was a rogue agency, particularly in the last administration. And I'll just ask a couple of questions. I'll start with Mr. Kim. You've got extensive experience with enforcement at CFPB, as well as the Administrative Procedures Act. And I've asked this before, I just want to confirm, does the APA apply to the CFPB?
It does.
And is agency guidance, is that a rule?
It is not.
Is a press release a rule?
No.
Is a simple statement by the director, is that a rule?
No.
Should a press release or a statement by the director be the basis of any enforcement action?
I don't think so. I can't think of a situation in which you should.
Right. Well, I agree with you. My understanding is that kind of thing was happening on a routine basis in the prior administration. Ms. Bassett, thank you for being here with us today. You've experienced this abuse firsthand as a small business owner. My understanding is your business was specifically targeted by the previous director, and you received a civil investigative demands. Can you explain what a CID is and what it's cost your business dealing with this mess?
Congressman, thank you for the question. Yes, so the civil investigative demand, it was unknown to me until I received one in July of 2022. But it's basically a subpoena, and where they're asking you for an unbelievable amount of an unbelievable amount of documents from our company, and the statement of purpose was very vague in general, and it was the same. They were issuing them to everyone in our or lots of people in our industry, and so the process is still ongoing for us, and it's been 3 years, and we spent close to $500,000, and for my small business, that is just crippling.
My understanding is that you lost about a third of the value of your business. Is that correct?
That's correct.
So, it just shocks me, and frankly, I wish more Americans knew about this rogue agency and how it is just wrong in terms of what it's done. I think that our constituents back home expect to know if they're dealing with any level of government, particularly the heavy hand of the federal government, that there are rules in place that protect them, that there is due process in place, that there's not an incentive, if you will, for an agency to go after them. And you had the entire funding stream, Mr. Chairman, the way CFPB was arranged. They were incentivized to go out and actually levy these fines, these penalties. That was the basis of their funding. And it would be the same as if you asked if a police officer got paid more if he wrote you up for a bigger ticket or something. And that is a fundamentally flawed system. And I think it goes to show why this agency, frankly, should be abolished. We have other agencies that can do this and have done a better job when it comes to actually protecting consumers instead of just trampling over people's individual rights. So I hope as we move through this session and as we tackle some of the other serious matters this committee has charged with dealing with, that this is something we will deal with. And with that, Mr. Chairman, I yield back.
Gentleman yields back. The chair now recognizes Mr. Fields of Louisiana for 5 minutes.
Thank you, Mr. Chairman and Ranking Member, and let me thank all of the witnesses for being here today. Ms. Harper, I do have a question for you. Given your research on financial industry practices, what do you anticipate will happen to consumer protection if the CFPB is effectively eliminated through workforce reduction or enforcement cessation? What alternative mechanisms could protect consumers from predatory practices that necessitate strong oversight? And what would you recommend to this committee to preserve meaningful consumer protection? And then, lastly, if you look at the states with the members on this committee, the complaints that have been lodged to the CFPB, you got over 500,000 in Georgia, and you got over 1 million in Florida. So with that, looking at that as your basis, what would be your response?
Well, thank you for the question, Congressman. And I think it's an important question, especially as we have folks that are reflecting on the past of what got us here. So not having, the CFPB not having resources, not being appropriately staffed, not really having any enforcement agenda to protect the rule of law to speak of, which is what we've seen under this administration, is laying the groundwork for another financial crisis. So it's interesting that so many of your colleagues on the other side of the aisle are saying we'd love to have all of these resources focused on the FTC, I should say, that there's other agencies that can handle this, that we can have these authorities scattered. That was the situation before the financial crisis. We've played that tune before, and it devastated the lives of millions of Americans. I think it's also very interesting that they're saying that, because if there's so much respect for the FTC, it's interesting that this administration has actually dismissed Democratic commissioners from the FTC that were doing the important work of some of that market monitoring and being able to look into investigations of different practices that might hurt consumers across the country.
Well, thank you. Let me ask a question to Ms. Bassett. Small businesses historically creates 2/3 of the new jobs. In my district, I have 2,478 older Americans who have filed complaints with the CFPB. How does eliminating transparency help these folk have access to the broader economic developments in our community?
Congressman, thank you for the question. I think I understand what you're asking, but I want to say that through the complaint bureau, through the CFPB has a huge database of complaints, and with that, my industry, which is small dollar lending, accounts for 0.08%, not my company, but my industry, of those complaints. So we don't. Our customers are very satisfied with our services, but maybe you can restate your question. Might have
make it very simple. I mean, how does you understand the complaints that we have at the CFPB, the Congressional Media Consumer Protection Bureau? You understand the number of complaints we have nationwide. You know, how would eliminating that department help consumers?
Thank you. Well, as I said before, you know, when I stated that I wanted to, you know, I didn't believe in keeping the CFPB, a part of that is just my personal experience, which has just been, and for our industry, it's just been such an overreach, and it just seems like an out-of-control agency at times.
Yeah, do you feel it serves any meaningful purpose?
For me, no. I was never accused of any violation of law or consumer harm.
Not for you, but for the consumer.
I'm sorry, I don't really have a complete answer for that. I think, you know, again, like the other gentleman said, I think there are other agencies that are available to protect consumers.
All right, name one in the financial industry.
Well, we have our state agencies that regularly audit us and also take complaints in as well. So I believe that our states have done a great job. We've been in business for 36 years, and so I believe that the states do a great job.
I yield back, Mr. Chairman.
Chairman yields back. The chair now recognizes Ranking Member Green of Texas for 5 minutes.
Thank you, Mr. Chairman. Thank the witnesses for testifying as well. And Ms. Harper, I especially want to thank you for your bold, brave, and brilliant testimony. You are a superior talent. BA from Tufts, JD from Stanford, MPA from Princeton, clerk for a federal judge, senior advisor to the director of the CFPB for some 3 years. You're a superior talent. And I must tell you something. I'm afraid for you. I'm afraid for you because of the vindictive nature that is permeating this society, emanating from the very top, from the President of the United States of America. There are some other people who would agree with me. I have in my hand statements from 25 current and former employees of the CFPB. I'd like to place them in the record, if I may, Mr. Chairman.
Without objection.
These 25 people have not allowed their names to be associated with these statements. They live in fear. These are former employees, not just the current. People who are no longer with the CFPB, afraid to be associated with the actions that they believe to be unfair and to some degree unlawful. We'll place this in the record. I'm afraid for you because I have in my hand an article styled "Trump Administration Sues All 15 Maryland federal judges over order blocking removal of immigrants." sued all 15 judges because he didn't like the decision. Where are we headed in this country? When we refuse to honor court orders, it's one thing for this to happen at some lower level by some lawyer. This is the President of the United States of America. He sets the tone and tenor for everything that happens in this country. I'm afraid for you. And I want you to know this. I'm going to stand with you. If you receive anything that causes you a good deal of consternation, causes some fear, I want you to contact my office. I am not among the pusillanimous politicians who are afraid to take a stand. I'm going to stand. And I appreciate the boldness and the brilliance of your testimony. Now, I have said earlier that what we are doing in this country does not only impact the CFPB. The Department of Education is being defunded. We cannot view these things in a silo. One hearing, one bit of information, and then we go to another. We have to connect the dots. Let's connect the dots. Defunding the Department of Education, crippling the ability to help our nation's most vulnerable children. Defunding HHS, which provides essential services, especially those regarding Centers for Disease Control, Food and Drug Administration. Defunding department known as HUD, the Department of Housing and Urban Development, at a time when Congresswoman Waters is trying to help more people get into homes. Affordability is a real problem in this country. She has legislation that would help with affordability, especially for first-time home buyers. But here's one that's personal. Defunding FEMA. I live along the Gulf Coast. I know what the severity of hurricanes is. I know how they impact the lives of people. If we defund FEMA, who's going to be there after a natural disaster to protect people who are sometimes living literally in the streets of life? We have gone too far now. We have put the people who live in the suites of life above all of the people, especially those who live in the streets. This country has to stop and take notice of what's happening. This president is destroying democracy in this country. Sir, you said you wanted to make sure that it's rule of law is the foundation. I respect you, Mr. Chairman. I'm going to yield back, but I'm going to tell this gentleman, you're right. It is, and it's being diminished by the President of the United States of America.
Chairman's time has expired. The chair now recognizes the chairman of the full committee.
User, it's good to have our panel to analyze the CFPB 15 years later. It's hard to believe that 15 years has passed by since Dodd-Frank, and all of you bring your expertise to our members, and so that's very, very helpful. You know, before I was in Congress, both in the brokerage industry and in the commercial banking industry, I was subject on and off to federal regulation for years, both in public companies and private companies. And I have to tell you, and I always tell my colleagues, I never once saw the federal government ever shirk its consumer protection enforcement responsibilities at any of the businesses I work for. In fact, quite the contrary. I mean, just intensively disciplining the businesses I was associated with, enforcing the law, enforcing the regulations. So you can count me as, I know there are exceptions and I know there are bad actors, and that's why we have federal law. That's why we have fair housing laws and consumer protection laws and credit protection laws, and they're all enforced, and they were enforced before the CFPB existed. So I want to be very clear about that. The question here is not whether this committee is interested in consumer protection. It's dedicated to consumer protection. The facts here are how to do it in the right way, the appropriate way, based on business strategy, business size, business entity, and in conjunction with what? The federal statute. the title of Dodd-Frank that set up the CFPB, being true to that statute and not inventing law out of whole cloth or operating by regulation, by enforcement. That is not the way our state and federal regulatory system, has operated over the decade. So, Mr. Kim, thank you for your enforcement responsibility. I looked at your resume. It looks like you were an early enforcement attorney working for Director Cordray, who I had the pleasure to know when I was first in Congress. And you've seen, as an attorney, outside attorney, good enforcement and bad enforcement, or enforcement over past the fringe of statutory authority. So I want to talk about that a little bit. Can you explain how the CFPB skirted the Administrative Procedures Act process by stating that it would consider discrimination as an unfair, deceptive, or abusive practice? UDAP, where we don't have the right defined terms here. We've been talking about this for years. Give me your assessment on that.
Thank you, Chairman Hill. On that specific issue, trying to impose anti-discrimination requirements through UDAP authority, you don't have to take my word for it. There's a district court in Texas that made that very ruling, right? That it was improper to basically legislate through an enforcement action, and that district court struck down that section of the UDAP manual that would impose these new kind of anti-discrimination requirements outside of existing federal law, outside of ACOA, outside of the Fair Housing Act, and by imposing it kind of through the back door as UDAP requirements through a manual, which is just a manual. Like I could write a manual. Not through the APA process.
Right. This is such a good point. Look, we have a system in place. Let's use it. If you want to come advocate through the Federal Register and promulgate a rule or promulgate the interpretation of a rule, do it.
What is this?
But this backdoor enforcement work, I just can't condone it. Ms. Bassett, do you believe that the CFPB under former Director Chopra engaged with you on a good faith basis? As I understand it, under Director Cordray, your work had been reviewed carefully and you'd been given a clean bill of health more than once, and then suddenly it's overturned by Director Chopra, and I don't think anybody thinks Richard Cordray's a patsy for the right. Where's the consistency in the application of CFPB procedures? Could you reflect on that?
Thank you, Chairman Hill. You're right. We were thoroughly examined by the Cordray CFPB. They sent 10 examiners to our small corporate office for 10 weeks in 2015. They visited 17 of our locations. At the end of that, again, there were no findings of law, no fines, no penalties. They came back in 2018, looked again, 10 examiners. They weren't there quite 10 weeks this time. But by the end of 2019, they had closed out that exam and there was no findings. And so then we're just going along, dealing with our state regulators, just business as normal. And 2022, in July, we get this CID out of nowhere. And it's very vague as to its purpose. And we were, again, there were multiple of those.
Thank you. My time's expired. I hope you'll expand to that in your answer in writing. And Chairman, thank you for the hearing. Yield back.
Thank you.
Chairman yields back.
I ask
Chair now
unanimous
recognizes
consent.
the gentlelady from
Submit to
Michigan,
the record.
Tlaib, for 5 minutes.
Unanimous consent.
Sir.
I request unanimous consent to submit to the record. Mr. Chairman, I ask unanimous consent to enter into the record a copy of Section 1016 of the Dodd-Frank Wall Street Reform and Consumer Protection Act, which requires this committee to hold a semi-annual hearing with the CFPB director. We have not done so since June 2024. I wrote Chairman Hill, reminding him of this requirement, and it's high past time that committee Republicans follow the rules and hold the current administration accountable. I have both documents to submit to the record. I ask unanimous consent.
Without objection. Chair now recognizes Ms. Tlaib of Michigan for 5 minutes.
Yeah, Mr. Kim, you're for-profit, right? For-profit?
I work for a for-profit.
Yep.
company.
Ms. Bassett, for-profit, right?
Yes.
How about you, Mr. Watkins?
I work at a nonprofit.
You're a nonprofit. Great.
Yes.
How about you?
Nonprofit.
Okay. I only say this because, some of the for-profit people are like, poof, the agency sent us a notice and y'all didn't do anything wrong. Like it just came out of thin air. And I want to apologize to you, Ms. Harper. I wasn't here. This institution, sometimes others, people that look like you and I, and try to dismiss us or silence us. And I apologize. I seriously apologize for that. There's no sense of, I think, really understanding sometimes our lived experiences or the passion that we have in advocating for what is important. This month, CFPB's acting head of enforcement, Kara Peterson, as you might have read or heard, and maybe you guys celebrated and had pizza or something, and she quit in protest of this administration's attempt to undermine the Bureau. And I want to quote her email. She said, quote, "Never before have I seen the ability to perform our core mission so under attack. It is clear," she said, "that the Bureau's current leadership has no intention to enforce the law in a meaningful way." Sadly, Ms. Peterson's departure should have came at no surprise to many of my colleagues. I mean, the administration's acting director vote have sought to fire, 90% of CFPB staff. They've dropped 22 pending enforcement actions against corporate lawmakers. And I want people that are listening, because I hear my colleagues really, 400,000 complaints by veterans, service members. I know for a fact that the fraud and the schemes targeting the American people right now is rampant. I know for a fact the bigger banks, their business plans are 50% junk fees and overdraft fees. Corporate greed is like a disease in our country and is hurting the American people. And so y'all acting like CFPB sitting there just picking on your donor friends. That's not right. They're doing wrong actions against people. They have to have actual evidence and complaints, y'all, to investigate. One of the things that I really is, they've overturned almost 70 pieces of non-binding guidance which can help inform consumers of their rights. Consumers are our residents, people, service members, seniors. The administration has allowed the backlog of 16,000 consumer complaints to pile up and has actually returned millions of dollars that were meant to compensate consumers back to the companies that broke the law, like the student loan servicers. I know they got the calls from their residents. You see how they were wrong, just really violating the process and so forth, and they got caught. The student loan servicers. They were supposed to give money back to, here he comes, and he's like, we're not gonna do that anymore. Ms. Harper, one of the things that I know CFPB, for me, I always explain to my residents, it's like the 911 for consumer protection. I know romance fraud, I'm being serious, like these outside entities, but in there is the corporations that set up plans and business plans because they know no one's gonna watch over them. I mean, CFPB didn't just come from thin air. It didn't just go, we're just gonna do this. It's because they were doing illegal, unlawful actions that were hurting the American people. Like they needed a babysitter. That's exactly what y'all need, is a babysitter, because you will never put our people in the best interest of the American people before the interests of your for-profit clients and schemes. So Ms. Harper, talk about the importance of CFPB and the reaction. I mean, right now, the reaction out there in regards to what is happening without any consumer protection.
Well, and thank you for the question, Congressman. I'm glad you used the term 911 because when you look at some of the complaints, and we've been talking about the consumer complaint database, you can actually feel the emergency and urgent emotions that the American people are having with things
They
like
have nowhere to go.
medical debt,
That's right.
being hounded at their jobs to pay medical debt that isn't the right amount, that they had no control over, that now is influencing their employment. The other thing I would note that's come up in terms of the risks that are in the market now, and it's more important than ever to have a CFPB that is staffed and focused on a strong enforcement agenda, is around big tech. We were talking earlier about entities that are outside the financial industry. Looking at big tech and how they are trying to move into payments, this is something the Chopra CFPB was trying to regulate and be able to have supervisory authority to see risk there. And this administration has completely rejected in the current leadership.
I only have 3 seconds because he'll cut me off. $3.5 billion in overdraft fees. I want residents out there in Republican, Democratic districts, no matter. $3.5 billion of overdraft fees that were illegal They've just let it go. We're not going to go ahead and enforce that. I just want the American people to know
Ladies,
exactly
time
what's
has
happening.
expired.
Mr. Chairman, request recognition to correct the record.
Ladies recognized.
I indicated that President Trump, based on the testimony of the...
Madam Chairwoman, my apologies. Time has expired. Cannot be recognized.
I want to correct the record. I ask permission to correct the record.
Is there a unanimous consent request?
The request that I'm making was, I quoted the gentleman who had...
No, lady's
the
not
record.
recognized.
President Trump has the power to pardon even the most atrocious terrorists and traitors, but for some reason...
Point of order,
an
Mr. Chairman.
unconstitutional settlement in a civil proceeding cannot be...
Gentlelady's not
This is
recognized.
wrong. And the gentleman tried to say that he did not say
Gentlelady
President
is
Trump.
not recognized.
That he said any president. The record needs to be corrected.
Mr. Chairman,
because
point of order.
The gentleman has written in
Ms.
the
Waters, the
record,
gentlelady is
President
not recognized.
Trump.
You understand
So I
that.
want the
Nobody would do
record
this during your
corrected.
hearing. It is
I want it
inappropriate
to be
and out of
corrected
order.
That the
I'd
gentleman
like to thank
said-
our witnesses for their
the
testimony
gentleman
today. I
said
request unanimous
that he
consent to
did
enter
not
two
say
documents.
President Trump. He did say President.
Ms. Waters, this is highly inappropriate and completely out of order. Yeah, nice. So I want to thank our witnesses very much. I request unanimous consent to enter two documents into the record. One is a statement from the Consumer Credit Insurance Association. The other document is titled The Abuse and Vilification of James and Melissa Carnes. Without objection, so ordered. Without objection, all members will have legislative
Mr.
days.
Chairman, I
within
have
which to
unanimous
submit
consent.
additional.
Soon as I'm finished, I'll yield to you.
Thank you.
Written questions for the witnesses to the chair. The questions will be forwarded to the witnesses for their response, and I ask our witness to please respond no later than July 31st, 2025. This hearing is adjourned.
Mr. Chairman, you were going to, by unanimous consent? You were going to entertain it by unanimous consent? I ask unanimous consent that Ms. Waters' comments be entered into the record as a
I object.
correction.
There is an objection. The hearing's adjourned. We're not going to do it twice.